matter of International Entertainment Holdings Ltd and others, and Allianz Insurance Plc.
Thank you, Ms. Higgs.
My lady, my lords, I appear for the appellants and the respondents to the cross-appeal, International Entertainment Holdings Ltd and various of its subsidiaries. And Mr. Doherty, Casey, and Mr. Killen appear for Allianz, the respondent and cross-appellant, as they did at first instance. My lords, my lady, as you know, this is an appeal from the judgment of Mr. Justice Jacobs regarding certain preliminary issues which arise in relation to my client's claim for business interruption losses. Mr. Justice Jacobs found against my clients on certain coverage issues, with the result that they had no coverage and their claim was dismissed. My client's appeal against certain of his decisions on those points. That appeal is with the permission of the judge, save for one ground where we did not in fact ask the judge for permission, but my Lord Justice Mayles granted permission. Allianz cross appeals with the permission of the judge against his decision in relation to limits.
Right. So thank you for that introduction. We've obviously read the papers. The necessarily long judgment obviously can be rather restricted for our purview because of the limited number of clauses that are under appeal. We know that there's been additions to the authorities bundle this morning, but I just wonder if at the moment we can look at housekeeping overall. It makes sense, I think, and my lords will say if they disagree with me, that we look at the appeal and the cross appeal as separate entities. So after you have made your submissions on the appeal, I will invite Mr. Doherty and Mr. Killen, if he follows, to respond, because it may be thought that if we're with you on the appeal, then obviously we can turn all fires to the other, but in any event we might not know at that stage, but we'll see how we go. But I think it will still be best to keep it in separate compartments. Does that cause you any concern?
No, my lady. I mean, subject to the court thinking, what Mr. Doherty and I had suggested between ourselves was that I would open my appeal, as my lady suggests, that Mr. Doherty would respond, but then he would open his cross appeal. Now, if you'd prefer to keep them entirely separate so that I reply to his response on the appeal, then we can of course take that course. But what he was intending to do otherwise was open his cross appeal. I would then respond to his cross appeal and reply on my appeal, and he would then reply on his cross appeal.
For myself, I think I'd prefer to have it separated, but we can see how we go, I think, once we've heard Mr. Doherty and Mr. Killen, if he follows, on the appeal. And we can decide where we are then. All right. What about timing? How are we on time division?
Well, my lady, I think we were intending to divide the time equally between us, but that what I had envisaged is that if I was opening my appeal, I was likely to be this morning and go slightly into this afternoon, not much. I think Mr. Doherty, on the basis that he was going to open his appeal, thought that he would go into tomorrow morning. But if he's not opening his appeal, I anticipate he'll say he will finish today, but I don't know.
All right, but we don't have to rush you if we're getting close to lunch, because you're already anticipating going slightly over.
I am anticipating going slightly over.
That's fine.
I may go quicker than hoped.
All right.
Just continuing on housekeeping, my lady, I hope the court has a core bundle and a supplemental bundle.
Yes.
And 3 bundles of authorities.
Yes.
The length of the authorities is in part only, my lady, because the FCA test case judgments are voluminous judgments. The other housekeeping point is we do have a transcriber in court, and if possible, if we could have a 5-minute break mid-morning for the transcriber, that would be helpful.
I'm sure that's all right. Yeah. That's all right.
My lady, I'm grateful for the indication that you've read the judgment, or at least the part of it relating to this.
We've read it all.
And I'm conscious that you will also have read the skeleton.
We have.
All I was intending to do by way of introduction was just show you the policy, just to explain in a little more detail how it works and put the clause in context. So if I could ask you to take the supplemental bundle. The policy wording is at tab 1, and the schedule is at tab 2. And it's the policy schedule, as you know, which contains the relevant clause. But if I could just start by looking at tab 1 and the policy, just to explain the structure of it. If you turn to page 1, in the middle of the page, just below the emboldened text, you have a paragraph that starts, "Your commercial select policy is made up of several parts, which must be read together as they form your contract of insurance with Allianz." And then going down to the next paragraph, "The parts of the policy which form your contract of insurance with Allianz are this introduction, the proposal, presentation of the risk, etc., the policy definitions, the insuring clause, the general exclusions and general conditions, all of which apply to all sections of the policy. Then the selections of cover selected by you, as shown on the schedule, the exclusions and conditions which apply to the sections selected by you, and finally the schedule, which includes all clauses applied to the policy while the policy is in force." And so the way the policy works is that the insured takes out the sections of coverage which it wants, and then there are specific policy wordings for each section. So if one flicks through this policy, the first 18 pages, one sees page 1 of 18 at the bottom of the page, are the introduction and the policy definitions. If one turns over the page, policy definitions, and then insuring clause, and then again over the page, general exclusions. If one turns to page 7, general conditions, and so it continues with the conditions that apply to all sections of the policy, and then there is some sort of administrative material towards the end of that section. So that's the first 18 pages. Starting at page 19, one has the property damage all risk section, and then flicking forward to page 43, the business interruption all risk section, estimated gross profit. And there are various definitions on that page, which we will later come back to. But again, flicking forward to see the next section, that starts at page 57 with the business interruption all risk section, estimated revenue. And then flicking forward again to page 69, the business interruption all risks section, gross rent, to page 85, the money section, 95, the employer's liability section, and page 103, the public and products liability section. So there's sort of self-contained wordings for each of the sections. If we could then turn to tab 2, which is where we find the schedule, and you'll see at the top it says amended schedule, because there were various amendments made to the cover, and this is the amended schedule. And one has on that page the insured, International Entertainment Holdings Ltd. That definition of the insured was in fact amended by a clause in the schedule, which we will see in a minute. And it was amended to identify the insured as International Entertainment Holdings Ltd. And subsidiary companies including, and then it sets out 16 named subsidiaries. One sees here the premium, the annual premium of approximately 1 million, and then a business description. Theatre, cinema, concert hall, ticketing and restaurant owners, operators, managers, theatre production company, marketing, design, communications, full service digital media and marketing agency. And again, there was in fact a slight amendment made by a clause later in the schedule to that business description. It's not material for current purposes, but it was slightly expanded. And that is all the various businesses which are carried on by the various companies within the group at their various premises. Below the business description, you see the clauses applicable to the whole policy. And then over the page, at page 116, the property damage or risks section. And at the bottom of that page, you see clauses applicable to this section. And then it says, please refer to the clause details for full wordings. And over the page again, and most importantly for our purposes, at page 117, you have the business interruption all risks section. And one sees the sums insured, and then towards the bottom of the page, clauses applicable to this section. And again, the words, please refer to the clause details for full wordings. And the relevant clause that we are interested in is shown over the page, about 6 lines down, S31, endanger life or property. And the wording for that clause, the clause details as it's described, appears on page 131. The court will probably be familiar with it already, but just to show the court where it appears in the policy, it's on page 131 at the top, and it says, denial of access, endanger life or property. Any claim resulting from interruption of or interference with the business as a direct result of an incident likely to endanger human life or property within 1 mile radius of the premises, in consequence of which access to or use of the premises is prevented or hindered by any policing authority, but excluding any occurrence where the duration of such prevention or hindrance of use is less than 4 hours, shall be understood to be loss resulting from damage to property used by the insured at the premises. And that's because the general business interruption cover is for business interruption cover resulting from damage to property. And so this deems this to be damage to property. And then there's a proviso, provided that the maximum indemnity period is limited to 3 months, and the liability of the insurer for any one claim in the aggregate during any one period of insurance shall not exceed £500,000. And that is obviously the clause with which we are concerned. With that introduction, I was intending to turn to ground 1 of my appeal. This was issue 28.1 at first instance, and the issue is dealt with in the judgment at paragraphs 459 to 482. The judgment is in the core bundle at tab 11. If we could turn to page 220. And the judge's conclusion is at paragraph 482. A case or case occurrence does not, in and of itself, themselves, amount to an incident likely to endanger human life within the meaning of clause S31. Although a case or cases of COVID are likely to endanger human life within the meaning of the clause, they does not, in and of themselves, amount to an incident. And my lady, my lords, we say the judge was wrong to so find. The reason that we say that the judge was wrong to so find are that the starting point of the word incident, the starting point is the ordinary meaning of the word incident. And we say that the ordinary meaning of the word incident is something which happens or occurs in a particular place, at a particular time, and in a particular way. It is a neutral word. It takes colour and meaning from the adjectives applied to it and from the context in which it appears. So some everyday examples. You can have an amusing incident, something that happens or occurs that is funny. A curious incident, something that happens or occurs that gives rise to questions. The curious incident of the dog at night time. You can have an embarrassing incident, one contemporary author describes his life as just a series of embarrassing incidents strung together by telling other people about those embarrassing incidents. You can have a tragic incident or an unpleasant incident. The word, the point I'm making, is that the word itself is a neutral word. It's a bland word, if I can put it like that. In this clause, the word incident, of course...
All of those adjectives, amusing, curious, embarrassing, tragic, unpleasant, denote some kind of effect on somebody, don't they?
They do in those contexts, with those epithets or adjectives applied to them, they would connote some sort of effect. But an unpleasant incident, I might say, is an extremely apt way to describe COVID, which has an unpleasant effect on the sufferer. And I, of course, do accept that the word incident takes colour from the adjectives applied to it and the context in which it appears. And the words that follow it in this clause are likely to endanger human life or property. So it is an incident which threatens human life or property. The word, of course, also needs to be read in the broader context in which it appears, which is a coverage clause in an insurance policy. And we say that in the context of a coverage clause in an insurance policy, it is being used neutrally as meaning something which happens in a particular place, way and time, which threatens human life or property. No more and no less than that. And we say that when bearing that ordinary meaning, incident has the same meaning as the ordinary meaning of the words event and occurrence. And in our submission, the ordinary meaning of the word incident is treated as having the same meaning as event and occurrence in everyday speech, in dictionary definitions, in insurance policies, and by the courts, and in particular by the courts in the business interruption insurance context. Could we look, please, start at the dictionary definitions? We've set this out in paragraph 17 of our skeleton, but if we could have a brief foray into volume 3 of the authorities bundle. Going to tab 18 to start with.
Sorry, I missed that. What number?
Sorry, tab 18.
Thank you very much.
What we have at tab 18 is the Oxford English Dictionary, and it's now online, hopefully, of event. And you see at the top of the page, event, something that happens or takes place, especially something significant or noteworthy, an incident, an occurrence. And if we could turn, please, to tab 20. This is also the Oxford English Dictionary, but actually the hard copy. The same does appear online, but we've put the hard copy in. And if one looks halfway down the page at the second text marked with red, it is marked, it says, an occurrence or event viewed as a separate circumstance. So the definition of event uses incident and the definition of incident uses an event. And then if we could turn, please, to page tab 21. This is the Oxford Dictionary of English. And at page 840, on the left-hand column towards the top of the page, we have the definition of incident. And the first definition is an instance of something happening, an event or occurrence. And there are examples given, several amusing incidents. There was not one incident of teasing from the 90 pupils. Come back to the other definitions, but the first definition is an instance of something happening, an event or occurrence. And finally, if we could turn, please, to tab 23. This is the Oxford English Dictionary of an occurrence. And the definition of occurrence is a thing that occurs happens or takes place, an event, an incident. So we say that the ordinary meaning of those three words is synonymous. Now, Mr. Doherty and Mr. Killen pray and aid some different dictionary definitions. There are further definitions of incident in the Oxford Dictionary of English, which they like and which they quote in paragraph 9 of their skeleton, which are violent event, such as fracas or assault, and the occurrence of dangerous or exciting things. And those are on page 840, which I just showed the court. Similarly, there's a definition in the online Cambridge Dictionary for incident, which they like, which is an event that is either unpleasant or unusual. And incident can, of course, be used in those senses. But we say its ordinary meaning isn't that narrow and specific. Incident simply means something which takes place in a particular time, place, and way. To use one of Mr. Doherty's examples, if a guest were accidentally to spill red wine on a bride at a wedding, that would certainly be an incident. It would not be a violent event or fracas. Allianz isn't contending and can't contend that the word incident in this clause is limited to violent event, such as a fracas or assault. It would include that, but it is plainly broader than that. We say it just bears its ordinary meaning, which is synonymous with the meaning of event.
If you did take that view, would you say the natural meaning of incident would normally be applied in everyday language to illness per se? Is it an incident to suffer flu? Or, I mean, that's the difference. None of the definitions you've taken us to refers to incident in terms of illness or disease, does it?
Well, my lady, I'm going to come on now and show you some insurance policies.
All right.
Where, and I'll just make this point now, many clauses, and I'm sure my Lord Justice Mells has seen them before, are termed notifiable diseases and other incidents. The premise of that title being that a notifiable disease and an occurrence of a notifiable disease is an incident. I also do make the point that the regulations, that we're not going to get into detail on today, I hope, were passed to deal with the spread of the incidence of COVID. Now, I accept it's a slightly different word, but they're from the same derivation, an incident and incidence. So we do say that incident is an entirely natural and apt way to describe an occurrence of a notifiable disease. And I think I help make good that point by looking at some insurance policies.
Just before we do, the incident on which you rely, as I understand it, is not simply somebody having the disease, but somebody either contracting it within the radius or having it already and going within the radius. Is that right? Or is it something else?
Well, my lord, that was the judge's decision at first instance, that an event or an occurrence could be where someone entered the radius or contracted. And that was in response to Mr. Doherty's submission that merely having a disease is a state of affairs, and it's not an incident because it doesn't happen in a specific place, time and way. Now, I would say that the Supreme Court were not so limited in the way they looked at this, and we can see in a moment what the Supreme Court said. They said that whenever someone suffered the disease, there was an occurrence within the ordinary and natural meaning of that word. So no, my case isn't that limited. It's the fact that someone has the disease within the radius that amounts to an incident. But if you say...
So the incident lasts for 5 days, 10 days, or whatever it is, for as long as somebody has the disease, is that right?
Yes. My lord, yes. Because something happening in a particular place, time, and way doesn't mean it has to be a split second, which is what the contraction was. But if you're not with me on that, and you say, well, incident means something more specific in terms of a time frame, then yes, I would say that someone entering the radius or contracting the disease is the incident.
Thank you.
We say that in this clause, as in many other policies, the words incident and occurrence are used synonymously. And if we could just look again at the clause, which is at page 131 of the supplemental bundle. Sorry, tab 2, page 131. The clause provides coverage for any claim resulting from interruption of or interference with the business as a direct result of an incident likely to endanger human life or property. And then it goes on in the third line, but excluding any occurrence where the duration of such prevention or hindrance of use is less than 4 hours. Now, we say that the two words occurrence and incident are being used interchangeably in this clause. Mr. Doherty and Mr. Killen, in paragraph 14 of their skeleton, say that's not the case because the words are not being used as alternatives there. Occurrence is being used to denote the incident and its consequences, i.e. the prevention or hindrance of use, not just the incident.
I don't think I need to remind everyone else to turn their phone off.
I'm sure that was enough of a reminder, my lady.
I'm sure.
We say to that the draftsman is not using language with quite the same meticulous precision and care that Mr. Doherty and Mr. Killen would attribute to him or her. He or she uses occurrence and incident interchangeably in this clause. He or she could have put incident where they put the word occurrence, but they just use the synonymous word occurrence. And in that regard, it's worth turning back to the previous page, where there's another denial of access clause, S29(1). We've just seen that the exclusion, the franchise period in clause S30, is any occurrence where the duration of such prevention or hindrance of use is less than 4 hours. In clause S29, if one looks at little Roman numeral I, it's excluding any incident involving an interruption of less than 4 hours duration. And as I say, these two words are simply being used interchangeably in these clauses. Moreover, that is what is commonly done in business interruption policies, where all three words, event, occurrence, and incident, are used interchangeably, and they are used to pick up my lady's point, in particular to refer to instances of disease. And a good example of such a wording is the QBE2 wording, which was considered in detail in the FCA test case. If we could go to the Supreme Court's judgment, which is in Authorities Bundle, Volume 2, at tab 9, page 437. And at page 437, starting at paragraph 87, the Supreme Court is considering two clauses, QB2 and QB3, which the divisional court had found did not provide cover. And essentially that was because the divisional court accepted the insurers' submissions that they provided narrow localized cover and so weren't intended to respond to the pandemic. And what the Supreme Court said is that there was no difference between these two wordings and the other disease clauses in which the divisional court had found that there was cover. They then said, however, the logic of the argument, in our view, points in the opposite direction, as we consider that the court correctly interpreted the disease clauses in QB2 and QB3. So the divisional court had correctly interpreted them as providing narrow localized cover. But of course, as we all know, the Supreme Court then went on to find that they did respond to the restrictions imposed in relation to the COVID-19 pandemic, because each and every case of COVID was a concurrent effective cause of the restrictions. But just looking at the clause itself, which is set out in paragraph 88, this covered loss resulting from interruption of or interference with the business in consequence of any of the following events. The first event is any occurrence of a notifiable disease. So there we say occurrence and event are being treated synonymously. And then if one looks down to subparagraph H, this is part of the proviso in the clause, provided that the insurer shall only be liable for loss arising at those premises which are directly subject to the incident. So again, we say that incident is commonly used in these business interruption policies to refer to any occurrence of disease. And that's because, as I said at the start of my submissions, the ordinary meaning of incident, the ordinary meaning, is simply something that happens in a particular time, place or way.
Is it, I mean, you may or may not be right about the ordinary use, but is it right to interpret one clause by reference to an entirely different clause dealing with a different peril,
Well,
which the policyholder may never have seen?
I accept that you can't interpret my clause by reference to this clause. I'm showing you this clause just to show that in the context of business interruption policies, incident is frequently used to refer to occurrences of disease. One of my lady's questions was, would an occurrence of a disease ordinarily be referred to as an incident? I say yes, not only as a matter of everyday speech, but in this very context, in business interruption context. And what I'd like to do now is go on to show you how the courts, in particular the Supreme Court and the Divisional Court in the FCA test case, also treated the three words as synonymous in this context. And I do say that case law generally, and the meaning that words have developed in cases, it is relevant to your exercise of construction. So in the FCA test case, in the Divisional Court at paragraph 404, said that they agreed that the word incident, in the clause before them, should be given the same meaning as event, something which happens at a particular place, in a particular way, at a particular time.
Do you want us to look at?
I'm going to take you to that passage in quite a lot more detail later.
Yes, so you might as well have it open now.
You can have it open now, but I'm going to sort of take you to some other places as well. But
Right.
I do promise I will take you back to that passage because it's an important passage. But what they did say, and there's no dispute about it, is that is an incident, the ordinary meaning of the word incident in that clause, which is, as the insurers will no doubt say, a very similar clause to our clause, is the same as the ordinary meaning of event. And in the FCA test case, and this in the Supreme Court, which I am going to take you to now, the Supreme Court that held that the ordinary meaning of the word occurrence, like its synonym event, is also something which happens in a particular place, at a particular time, in a particular way. And that, I think, is worth going to now. That's at volume 2 of the authorities bundle, which you may still have open, at tab 9, at page 431. And it's at paragraph 67. The word occurrence, on the other hand, like its synonym event, has a widely recognised meaning in insurance law, which accords with its ordinary meaning as something which happens at a particular time, at a particular place, in a particular way. And we say that's very well established as a matter of insurance law. And as we know, the Supreme Court in the FCA test case held that each individual case of COVID was properly regarded as an occurrence. And that's paragraph 104 of the Supreme Court judgment. We could go to that, that's page 441. The passage marked in red. As in the other policy wordings, we consider that the word occurrence should be given its ordinary meaning of something which happens at a particular time, at a particular place, and in a particular way. As discussed, each individual case of disease is, in our view, properly regarded as an occurrence. Accordingly, when there are multiple cases of disease, each is an occurrence within the meaning of the clause. So, my lady, my lords, we have the highest possible authority for the proposition that a case of COVID is properly regarded as an occurrence within the ordinary meaning of the word occurrence, that ordinary meaning being something which happens at a particular time, place, and way. And we say that it follows that a case of COVID is properly described and regarded as an incident within the ordinary meaning of the word incident. And we say, if you were to substitute the word occurrence or event in clause S30, it could not sensibly suggested that the meaning or scope of the word would change. Clause S30 provides cover in circumstances where there is an incident likely to endanger life in consequence of which access to use of the premises is prevented. And we do say that a reasonable policyholder would be astonished if they were told that this clause did not provide cover, but had the clause referred to an occurrence likely to endanger life or an event likely to endanger life, it would have provided cover. The reasonable policyholder would quite rightly have made the riposte that the word incident, used in its ordinary sense, is synonymous with the word occurrence or event, and that there can't sensibly be a different meaning or outcome depending on which of those three words had been used in that clause. Mr. Justice Jacobs, at paragraph 495 of his judgment, and my Lord Justice Males has already picked this up, held that there was no reason why there should not be an occurrence or an event if there was a transmission of COVID within the radius or if a person who has COVID enters the radius. My lords, my lady, I've just shown you the passage in the Supreme Court where occurrence was referred to as a case. Well, Mr. Justice Jacobs was responding to Mr. Doherty's submission that, well, it's got to be more specific than just a case. It's got to be more localised in time to be an event. And Mr. Justice Jacobs said, well, if that's right, then there's an event when you enter the radius or you contract COVID. But on any view, that's an event. And we say exactly the same is true of an incident. There is no reason why someone entering the radius with COVID or contracting COVID within the radius isn't an incident in exactly the same way that it's an event or an occurrence. Mr. Doherty's argument at first instance, and I think maintained on this appeal, is that every event is an incident, but not every incident is an event. That argument, I think, is reiterated. Sorry. Apologise, quite right. He says that in ordinary usage, the word incident has a negative connotation. I've already addressed that. I say it's a neutral word. It can be given positive or negative connotations depending on its context. In his skeleton, he says, well, a wedding would be described as an event, but it wouldn't be described as an incident, apparently to indicate that the two words are not synonymous. But the reason why you would describe a wedding as an event is because event can also be used more specifically to mean a public or a social occasion. That is one of the specific definitions given in the Oxford English Dictionary. Our point is that the ordinary meaning of incident is the same as the ordinary meaning of occurrence and event. And we say that the FCA test case, among many other authorities, provides clear authority for that. Now, the reason why the synonymous word event is not used in clause S30 may be because event is a defined term for the business interruption section of the policy. And if we could just please look at that definition by going to the supplemental bundle at tab 1, page 43. These are the definitions which are used for the business interruption all risks section estimated gross profit. But in fact, the same definitions apply for the revenue section and the rent section of the business interruption policy. And event is described as accidental loss or destruction of or damage to property used by the insured at the premises for the purpose of the business. That's what event means. It's used, I won't take you to all the many, many times that it is used throughout the business interruption section, but event is given a defined specific meaning, damage to property, in this policy. So a different word is used in clause S30, and instead of the word event, the synonym incident, and in fact another synonym, occurrence, is used. Another of Mr. Doherty's submissions at first instance, and again I think maintained on appeal, is that an incident connotes something overt, not latent, and that an undetectable or undiscoverable happening could not be an incident. And that submission is recorded at paragraph 468 of the judgment. And Mr. Justice Jacobs apparently accepted this submission. At paragraph 474 of the judgment, and perhaps worth looking at this, it's in core bundle 11 at page 218. Sorry, 218, page 474. After he has referred to the divisional court's judgment, which I'm going to come back to and deal with in detail, he says about halfway down the paragraph, I also consider that the word incident in ordinary usage does connote a happening which is apparent at the time, often to very many people. Notwithstanding that it can be used synonymously with occurrence, it would be unusual to use the word incident to describe something which no one perceived at the time. Mr. Doherty accepted that a burglary which is witnessed by no one and whose existence is not discovered until weeks later would nevertheless be an incident. However, even that incident would be apparent at the time to the burglar, and is therefore not an example of an incident which no one was aware of at the time. And then he goes on to say that given that the overriding question is how the words of the contract would have been understood by a reasonable person in the position of an ordinary policyholder, cannot conclude that the divisional court was wrong in the conclusion that was reached on the Hiscox wording. Now, on this covert or overt latent question, the first point that we make about the judge's reasoning in that passage of 474 of the judgment is that there are lots of happenings which are not seen or known about by anyone at the time that they occur, but which are nonetheless naturally and properly regarded as and described as incidents. A flood at a home whilst the owners were abroad. The homemaker is making a claim on his homeowner's policy, and the insurer asks, when did the incident occur? And the homeowner might well respond, it occurred when we were on holiday. We weren't there at the time that the incident occurred, but when we returned later, it was obvious that there'd been a flood sometime previously. A boiler exploding would undoubtedly be described properly as an incident, something that happens in a particular time, place and way. The fact that it's not witnessed by anyone at the time that it happens is nothing to the point. In any event, we suggest that this whole argument about whether a case or an occurrence of COVID cannot be an incident because the cases of COVID were not known about proceeds on a false premise. In March 2020, the government was reacting to known unknowns. It knew that there were cases of COVID throughout the country, even though it wasn't known at the time exactly who did and didn't have COVID. And the government introduced the restrictions in response to, and as a result of, all cases of COVID, known and unknown. And again, that's been well established by authority. So the cases of COVID were not unknown, undetectable, undiscoverable incidents. Apart from anything else, a case of COVID, even if asymptomatic, can be identified or discovered through testing or diagnosis. The next point that we make about the judge's reasoning in paragraph 474 is it appears in fact to lead to this conclusion. If there were a reported or a diagnosed case of COVID within the radius, or even if someone knew they had COVID at the time, even if it wasn't officially diagnosed, then there would be an incident within the meaning of the clause, because the case was something which was apparent and was known about at the time. Whereas, on the judge's reasoning, if someone had COVID but was asymptomatic, then there wouldn't be an incident. So in fact, on his own reasoning, the judge's answer to the question should be not that a case of COVID is not an incident, but rather that a reported, diagnosed or symptomatic case of COVID is an incident, and it's only asymptomatic cases of COVID that are not an incident. Actually, as far as we can tell, that does appear to be Allianz's case in its skeleton for this appeal, because if it says in paragraph 19 of its skeleton that a case of COVID is, of course, not in and of itself ordinarily observable, so cannot amount to an incident. So what appears to be accepted is that if it is observable, you can see that someone's coughing or sneezing, suffering from COVID, then that would constitute an incident. But we say that distinction is wrong. Both the cases of COVID which were reported and known about at the time, and cases which were not specifically known about at the time, but existed, are properly termed as incidents likely to endanger life within the meaning of the clause. And that's because they fall within the ordinary meaning of the word incident. Now, I do accept that there is a limit to how much other clauses in this policy throw light on the language used in this clause, because as Mr. Justice Jacobs said, this is something of a pick and mix policy where clauses have been brought in, so I accept that. But nonetheless, I do point out that when this policy wants to specify a particular sort of incident, it uses language which does that. And if we could go, please, to Supplemental Bundle 1 in the policy wording, which I showed you at the start, to page 110. And what we're looking at on page 110 are the exclusions to the public and products liability section. If you look at exclusion 4B, there is an exclusion for pollution or contamination liability in respect of pollution or contamination occurring elsewhere, and that means outside the US, unless caused by a sudden, identifiable, unintended, and unexpected incident, which takes place in its entirety at a specific time and place during the period of insurance. Now, their incident is being used in a much more narrow and specific way. We say the word incident in and of itself does not denote all those things. It takes those adjectives to make it mean that. My lords, my lady, I was going to turn now to the FCA Divisional Court decision, which was of paramount importance to Mr. Justice Jacobs' decision. in effect, Mr. Justice Jabez concluded, as he did on several points in these cases, that he shouldn't depart from the divisional court's judgment unless he considered that it was wrong. So I'd like to turn to the divisional court's decisions and show you what they decided and why we say it was wrong. The authority is in Volume 1, Tab 8. And the relevant discussion starts at page 335. And as the court will know, this was a decision of Mr. Justice Butcher and Lord Justice Flo sitting as a divisional court. And the clause that they were considering was the Hiscox non-damage denial of access clause, which is set out at page para 391, which is on page 335. And that says, non-damage denial of access, an incident occurring during the period of insurance within a 1 mile radius of the insured premises, which results in a denial of access or hindrance in access to the insured premises, imposed by any civil or statutory authority or by order of the government or any public authority for more than 24 hours. And like the QBE2 and QBE3 wording, which I showed you briefly earlier, the divisional court held that this effectively provided narrow localised cover and didn't respond to the COVID pandemic. And that decision of the divisional court was not appealed to the Supreme Court. So we don't have the benefit of the Supreme Court's analysis of this clause. But of course, the landscape has changed a little bit on the causation front as a result of the Supreme Court's decision. The primary argument that was made by the FCA in relation to the Hiscox non-damage denial of access clause was that the pandemic as a whole was an incident occurring within a 1 mile radius of the premises. And that submission is recorded in paragraph 393 of the Divisional Court's judgment. In the alternative, Mr. Edelman for the FCA argued that the requirement of an incident within 1 mile was satisfied by the occurrence of COVID within a 1 mile radius. And that submission is recorded in paragraph 395. Mr. Gazeman's response for Hiscox, response to the FCA's submissions, is set out in paragraph 398 of the judgment, at the bottom of the page on 336. And Mr. Gazeman, with characteristic robustness, described the FCA's case for coverage under this clause as feeble and hopeless, and he agreed, 4 lines down, agreed that an incident is to be equated with an occurrence and an event, and submitted that Lord Mussel's dictum in Axter and Field, that in ordinary speech an incident is something which happens at a particular place in a particular time in a particular way, was equally applicable to an incident. But his submission was that the FCA couldn't possibly satisfy the requirement for an incident. And the reason he said that is that, bottom of the page on 336, in context, what the clause was focusing on was something occurring within a 1 mile radius of the premises or in the vicinity of the premises. Some local incident, such as a burst water main or a gas leak or a traffic accident or a crime. Then he went on to say, a national pandemic such as COVID-19 was not an incident with the meaning of the clause. It was too geographically dispersed, too prolonged, too variegated, and too non-specific to qualify as an incident. Likewise, he submitted that the presence of someone within the 1 mile radius or in the vicinity of the premises who had COVID could not possibly be described as an incident. That person might come and go without knowing he had the disease, and people might not know he was infected. Such an undetectable happening could not be an incident. So those were Mr. Gazeman's submissions. And just looking down to what else Mr. Gazeman said, at paragraph 403 at the bottom of the page, he also made the point that the further insurmountable problem which the FCA faced concerns causation, and he said that he submitted the cause of the imposition of the regulations was the national pandemic emergency, but that was incapable of being an incident, and on the FCA's alternative case, that an incident was the presence of someone infected with COVID, even if that was capable of amounting to an incident, which it was not, it could not possibly be said to have been causative of the restrictions imposed by the government. That's where I say the landscape has changed post the Supreme Court's judgment, because the Supreme Court has clearly and undoubtedly found that each individual case of COVID is capable of satisfying the proximate causation requirement in these clauses. So those are the reasons that Mr. Gazeman submitted the clause did not respond. And the critical 2 paragraphs of the Divisional Court's decision follow at paragraph 404, where the Divisional Court says, in our judgment, the FCA's entire case on this clause founders on the requirement for an incident. We agree with Mr. Gazeman that this should be given the same essential meaning as an event, something which happens at a particular time, at a particular place, in a particular way. Then they go on to say the further geographical restriction seems to us to confirm that this clause is intended to cover local incidents, of which the paradigm examples are a bomb scare or a gas leak or a traffic accident. Then they make a further point about locality. Then they say in paragraph 405, contrary to the FCA's pleaded case, an incident is not synonymous with emergency or danger. The incident could in any could be said in any case to cause an emergency or danger to arise, but it is not synonymous with it. Whilst in other wordings, other than the Hiscox wordings we are considering, the COVID pandemic can properly be described as an emergency which is likely to endanger life, it is a misuse of language, both generally and on the correct construction of this clause, to describe the pandemic as an incident, let alone an incident occurring within a 1-mile radius. It may amount to a state of affairs, but it is, as Mr. Gazeman put it, too geographically dispersed, variegated, prolonged, and non-specific to amount to an incident. We consider that Mr. Gazeman's analysis correct. Saying that the pandemic is everywhere does not mean that it is present at a particular insured premises, and certainly does not mean that it amounts to an incident. And then we have the critical few lines at the end which relate to this point. It is no answer for the FCA to say that there is an incident if someone with COVID-19 is present within the 1-mile radius. As Mr. Gazeman said, that person might or might not know he or she had COVID, and in any event, it is a misnomer to describe the presence of someone in the radius with the disease as an incident for the purpose of the clause. And that was the passage that Mr. Justice Jacobs felt that he was effectively bound to follow, and only depart from if he considered it was wrong. And we say it was wrong. The first point I make about this is that the point was not extensively argued. I don't say the point wasn't addressed by the Divisional Court. It was, but I was there and it was very briefly addressed. It was one of a plethora of issues which Mr. Justice Butcher and Lord Justice Flo had to address in their very extensive judgment. The argument that each case of COVID amounted to a separate incident was very much not at the forefront of the FCA's case, because prior to the Supreme Court's concurrent causes analysis, it was not contemplated that there would be cover if the clause only responded to localised incidents. It was considered that that wouldn't be sufficient to amount to give rise to a right to indemnity. Where we say the Divisional Court went wrong, with respect, was in focusing on the so-called paradigm examples, a bomb scare, a gas leak, or a traffic accident, and then concluding because those were the paradigm examples of incidents, it was a misnomer to describe the presence of someone with COVID in the radius as an incident for the purpose of the clause. the Divisional Court does not explain why it is a misnomer to describe a case of COVID as an incident. It doesn't explain that, although it is accepted that the ordinary meaning of incident and the meaning of incident in the clause it was considering is simply something that happens in a particular place, time and way. Now, a case of COVID might not be the classic or the paradigm example of an incident falling within the scope of this cover. It might well not be the first example that springs to mind. A gas leak may be the first example that springs to mind. But that is not the end of the inquiry. And indeed, we say that the approach of starting with the paradigm case and then asking whether this looks like the paradigm or is similar to the paradigm is in fact fundamentally the wrong approach. And the court's approach should not be to approach the clause on the basis of the paradigm, but rather to ask whether what happens falls within the scope of the wording used by parties in the insuring clause. And that was a point that was made by Mrs. Justice Cockerell in Corbyn and King. And perhaps worth looking at it briefly, in the authorities bundle in volume 1 at tab 6. And the relevant passage is at page 190. At paragraph 202, and sorry, we may look back a couple of pages, but what she says is, in essence, I regard this reasoning as being overly concerned with the paradigm and inferred subjective intention, and not enough with the wording. And if we could, sorry, just look back a couple of pages at 178, where she first makes the point. Paragraph 178, which is on page 184. She says, the second problem is that as a matter of law, we do not construe contractual provisions by reference to such paradigms or such evidence of historical derivation. And we say that with respect, what the Divisional Court did do was construe the Hiscox NDDA clause by reference to what it regarded as the paradigm situation to reach the unexplained conclusion that a case of COVID wasn't an incident. In our submission, the Divisional Court's unexplained conclusion that a case of COVID is not an incident is first inconsistent with its own correct conclusion that an incident means the same as an event, something which happens in a particular place, time and way. And second, is inconsistent with the Supreme Court's conclusions that the ordinary and natural meaning of the word occurrence is also something which happens at a particular place, time and way, and the Supreme Court's conclusion that each case of COVID was indeed an occurrence within the ordinary meaning of that word. Now, as I've said, the Divisional Court's decision on the Hiscox NDA clause was not appealed to the Supreme Court, but we do say that the Divisional Court's conclusion, if it can be termed that, on this particular point, and in particular what it said at the end of paragraph 405, cannot stand because it is impossible to square with and is inconsistent with the Supreme Court's conclusion that each case of COVID is an occurrence within the ordinary meaning of the word occurrence. Now, what might be behind the Divisional Court's apparent conclusion that a case of COVID might or might not, point that the case of COVID might or might not be known about, is really a causation point. The court's mindset at that time was that someone in the area with an unknown, undiagnosed case of COVID couldn't have been the proximate cause of the restrictions. But of course, the causation goalposts have moved following the Supreme Court's analysis of concurrent causation. So for those reasons, that the point was only briefly addressed in the Divisional Court, and we say the Divisional Court wrongly approached the matter of construction by approaching it with a focus on the paradigm situation rather than looking at the language and asking whether it falls within the scope of the language, we say that those two sentences at the end of the Divisional Court's judgment in paragraph 405 are wrong and cannot stand in light of the subsequent analysis of the Supreme Court. And we also make one further point about our clause as opposed to the Hiscox NDDA clause. The clause there just referred to an incident within a 1 mile radius. In our clause, it is an incident likely to endanger human life or property within a 1 mile radius. Now, as you know, a further ground of appeal is whether the 1 mile radius attaches to the incident or to the human life or property. But on any view, it has to be an incident which is likely to endanger life or property. And if a reasonable policyholder were to ask him or herself what sort of happenings are likely to endanger life or property, the examples which do come to mind are things like traffic accidents, violent attacks, fires, explosions, collapsing buildings, but also serious diseases. They are events, incidents, which are likely to endanger human life. And in that point, we've just made one final point about the wording of our clause, and that is that there is no exclusion in this clause for infectious and contagious diseases. And that can be contrasted with a clause that immediately precedes it in the policy, which again, sorry to take you back to the supplemental bundle. But in the supplemental bundle, in the schedule at tab 2, at page 113, sorry, 131, I apologise. If one just turns back to page 130, one sees the denial of access clause, which is another clause. And then at the end of that clause, there is an exclusion, goes over the page, for any consequence of labour disputes or infectious or contagious diseases. Our clause, unlike that clause, does not have such an exclusion. We say an occurrence of an infectious disease, serious infectious disease, is something which is likely to endanger life, something which happens which threatens life, and the fact that there is no exclusion for infectious or contagious diseases in our clause, by contrast with the previous clause, is a telling point and indicates that it does cover infectious and contagious diseases. I'm conscious that it's now 11:45, and that might be a sensible time to take a break if it's convenient to the court.
Oh, you finished with ground one?
I've nearly finished with, I've got 2 more points to make on ground one, so if you want, I could just finish that and then I'll move on to ground.
That might be the best place for
that would be a better
break.
Place, that would be a better, I take
All
that
right.
point. Thank you, my lady. The next point I wanted to deal with just briefly is Mrs. Justice Cockerell's decision in Corbyn and King, from which the judge also derived some support for the conclusion that he had reached, that he should not depart from the Divisional Court's decision. And he says that in paragraph 475 of the judgment. You don't need to turn that up. But if we look at Mrs. Justice Cockerell's decision, that is in volume 1 of the authorities bundle. At tab 6, at page, the relevant part, it starts at page 180. And the first point I would just make is this. The clause which Mrs. Justice Cockerell was in fact considering and construing Corbyn and King didn't refer to an incident at all. It referred to a danger. And what she is doing in these paragraphs of her judgment is pointing out differences between the wording that she is considering and the various wordings which the Divisional Court had considered. She then goes on to make some comments about incident. But I would submit that it is fair to say that they are passing comments by Mrs. Justice Cockerell, because she wasn't concerned with the meaning of incident. It wasn't in the clause before her. It wasn't the subject of any argument at all before her. And what she says in paragraph 156, while I would tend to agree with Lord Mance that the difference between vicinity and a 1 mile radius wording might not be enough to draw a distinction between two otherwise identical wordings, there are greater disparities here. Emergency likely to endanger life in the vicinity may mean something different to a danger within a mile. The word incident also is capable of lending a very distinct colour to a wording, as the telling argument recorded at 398 of the Divisional Court's judgment makes clear. That's the argument of Mr. Gaisman, which I just showed you. Its significance is undermined by the Divisional Court's conclusion at 404 that in our judgment the FCA's entire case on the NDDA founders on the requirement for an incident. So, what I say about this is that Mrs. Justice Cockerell was not considering a wording with the word incident. There was no argument before her about it. It is a passing comment and only that. We respectfully disagree that the word incident lends colour to a clause, precisely because, as I started off my submissions by saying, incident is a neutral word. It doesn't lend colour. Adjectives and context might lend colour to it, but it is itself a neutral word. Mrs. Justice Cockerell also went on to say, and this is in paragraph 157, I would also tend to the view that the precise wording of the authority or the length of the franchise period might well have an impact. For example, incident teamed with an authority wording led off by local authority, police, emergency services, and a short franchise period would certainly have a real sense of pointing towards the paradigm situation. And then she says there are some other factors. And then what she does is conclude that there are enough differences between the wordings that were considered by the Divisional Court and the wording that she's considering to mean that effectively she's not bound by their decisions on any of the points. Now, Mr. Justice Jacobs said at paragraph 476 of the judgment that in this case, as the franchise period was 4 hours and the relevant authority was a policing authority, those factors provided additional reasons why he should not depart from the Divisional Court's conclusion that an incident did not include a case of COVID. We say these factors actually point in our favour, if anything. The franchise period is 4 hours and the maximum indemnity period is 3 months. So this clause undoubtedly contemplates incidents which are of a reasonably serious nature because they have to be more than a few hours duration to engage coverage, and because they might have very long-lasting impact on the businesses over 3 months. I'm going to come on, as you know, to policing authority, but we actually say it's a very broad and flexible term, so it doesn't point to the paradigm situation in the way that Mrs. Justice Cockerell suggested it might, or Mr. Justice Jacobs thinks it did. That was all I was going to say on the first ground. Mr. Doherty and Mr. Killen rely, I think, on some FOSS decisions. I don't think they assist this court. If there's anything he says about them in his response that I need to reply on, then I'll do that. But that was all I was going to say on ground one.
So you'd like the 5 minutes now?
5 minutes, I think.
Yes, of course.
Thank you very much.
We'll do that.
All right.
Yeah, sorry.
All right.
Thank you. Mr. Transcriber, is that sufficient?
Turning now to the second point, which is whether the incident itself has to occur within the 1 mile radius, or whether it's sufficient that life or property within a 1 mile radius is endangered. This was issue 28.3 at first instance. It's a short point, as my Lord Justice Mail said when giving permission, and I'm going to take it shortly. The judge dealt with the issue at paragraphs 485 to 493 of his judgment, which is in the core bundle at tab 11, page 220. Right at the bottom of the page.
Sorry, can you give me that reference?
Sorry, it's core bundle, tab 11, page 220.
Yes, I've got it.
And
Thank
the
you.
consideration starts at the
Yes.
bottom of the page. And the judge held that the incident itself has to take place within the 1 mile radius. We say that the judge erred in reaching that conclusion, and that a proper construction of the words, the incident can take place outside the 1 mile radius, as long as it endangers life or property within the radius. And it is worth having the clause in front of you, which we can get from the judgment.
Did you say this was ground 2?
I'm so sorry, it's the second
It's ground
point,
3.
But it's ground
Yes.
3. I think it's
Yes.
more logical if you're
Yes,
happy
of
for me to do
course.
so. To take
Yes,
them as order.
absolutely.
The clause is just a few pages back at 214. And the words that we're interested in are, as a direct result of an incident likely to endanger human life or property within 1 mile of the premises. And there are 2 rival readings. The first is that the words within 1 mile radius of the premises qualify and relate to the words human life or property, which appear just before it, i.e. you read the words in the order in which they appear. The second is that the words within 1 mile of the premises relate back to the word incident, so that both the phrases likely to endanger human life or property and the phrase within 1 mile of the radius of the premises qualify the word incident. We contend for the first reading, Allianz for the second reading. In our submission, the much more natural way to read the phrase is to read the words within 1 mile radius of the premises as attaching to and qualifying the words which immediately precede it, i.e. human life or property. If it had been intended that the incident itself had to be within a 1 mile radius of the premises, it would have been much more natural to put the words within 1 mile radius of the premises immediately after the word incident. I say that the natural approach is to read and understand the words in the order in which they appear, and there is no reason to read the words within a 1 mile radius as qualifying the earlier word incident as opposed to human life or property, which they appear immediately afterwards.
So if somebody had contracted COVID in China at the start of the pandemic and brought the disease into the country and attends at the theatre or the restaurant or within a mile radius, you say that would be covered?
I don't... Sorry, the incident has to be one which is likely to endanger life or
within a
property.
mile of radius.
I don't suggest for a moment that someone contracting COVID in China is something that could endanger life or property.
No, but if they came back into the country still contagious, so the incident is the contraction of the disease, or it's the movement into the radius. That's your point.
Yes.
Yeah, I understand.
Yeah.
So wherever the contraction occurred, the disease, providing their movement was such within the radius, and they were still contagious.
Yes.
That's the continuation of an event, an occurrence, and it's an incident.
Yes. Well, my lady, I put it slightly. Could I take it away from COVID for a moment?
Yes, of course.
And let's take another incident. Let's take a gas leak.
Yeah.
I say that the gas leak itself does not need to occur within a 1 mile radius, as long as it endangers human life or property within the radius. Now, I quite accept that the further you get geographically from the radius, the less likely it is that the likely to endanger human life or property in the radius will be satisfied. But what I say is a gas leak which takes place 2 miles away from the premises may well endanger life or property within the premises, and that would be covered by this clause.
But if you accept that the greater the geographical distance, the more difficult your submission would be, doesn't that play into the respondent's hands? Because where do you draw the geographical limit?
Well, I'm going to come on to explain how we say the geographical limit works and why it's included. But at the moment, I'm just focusing on the words in the order in which they appear.
Yes, of course, I understand.
And I just make this submission at this point that the natural order to read the words is the order in which they appear. But I will come on to deal with your ladyship's point.
I was going to say, just in terms of the order of words, the words immediately after 1 mile radius of the premises, that is the words in consequence of which, they refer to the incident, don't they?
Well, they refer compendiously to the whole, as it were, prepositional phrase that goes, or not preposition, noun prepositional phrase that goes before it. They refer to incident likely to endanger human life or property within 1 mile of the radius, then in consequence of which. So you have to have all of that in order to have consequence. So I don't think it's right to say they refer back to the incident. They refer back to the incident with all its attributes.
Well, just to I understand that, but can I suggest it's not maybe as simple as that? Because one way of interpreting the argument could be to say that by trying to say that the 1 mile radius refers to the endangering of the life, why doesn't the in consequence refer to the endangering of the life? But it clearly doesn't. It refers to the incident, the endangering of life.
I accept that.
Okay.
And to be clear, I don't say that Mr. Doherty's reading is an impossible reading. It's a possible reading. I think Mr. Doherty says mine can't be read on any sensible view. It can't be read as I say it does. Well, I disagree with that, but I accept his is a possible reading. I say mine is a more natural reading.
If we're, if you're right about that, and there is a genuine ambiguity in the language of the clause, how do we resolve it? One possibility, I suppose, is that we look at the practical consequences. If Mr. Doherty is right, and it is the incident which has to be within 1 mile of the radius, then all that the insured needs to show is that there was an incident which took place within the correct geographical area and that it endangered life or property. Whereas if you're right, you need to show not only that there is an incident, but you need to investigate how far away or how close the incident needed to be in order to have that effect within the radius. So if we take the gas leak, then you'd be needing to find out what the consequences would have been if the explosion had happened, which might depend on how much gas there was or how bad the leak was, which is getting quite a long way away from the kind of thing that the insured might be able to investigate.
Well, my lord, just taking that in stages. The first stage is, I accept that if there's a genuine ambiguity, then one looks at the commerciality and the common sense of the rival interpretations. I just conceded that Mr. Doherty's reading was a possible reading on the language, and I do accept it is a possible reading, but I still say mine is the much more natural and reasonable reading. But when I come on to address commerciality, I will be making the submission that actually the question of whether or not life or property is endangered within the radius is almost answered, I don't say it will be in every case, by the fact that prevention of access to the premises has been, by a policing authority, has prevented access to the premises. Because of course the clause isn't satisfied merely by showing that there's an incident which endangers life or property in the radius. It has to result in access to the premises being prevented or hindered by any policing authority. And by and large, policing authorities won't go around closing properties where there's no local danger to life or property. So I don't accept the suggestion that the insured would have to investigate whether the gas leak was such as, 2 miles away or 3 miles away, would it have made a difference? I do accept that it might be possible for the insurer, if it was taking every conceivable point, to say, oh, well, access to your property was prevented. There was an incident likely to endanger life, but actually the authorities overreacted and there wasn't actually a threat to life or property in your area of your premises.
I suppose the difficulty is that we're having to apply this clause to a situation, namely a worldwide pandemic, or even a national pandemic, which was not in mind when it was drafted. I mean, if we take the facts of COVID, maybe it's too much of a stretch to say that the contraction of the disease in China, in the markets of Wuhan or wherever it was, endangered life or property at one of your restaurants. But once it got into the country, once people started arriving from China or via Italy or wherever they came from with the disease, then we now know that life was endangered all over the UK. But is that what this clause is talking about?
Well, my lord, I still accept, as I say, that it is a requirement that the insurers can deny coverage on the basis of that it doesn't, in fact, endanger life within the radius. And so it's not part of my case that the first time COVID comes into England, there is an incident likely to endanger life. That's not my case. The only point on this is whether the incident itself has to occur within the radius, or whether it is possible for the incident to be outside of the radius as long as it does in fact endanger life in the incident within the radius. So I accept there could well be an inquiry which hasn't been answered at the moment about how far does a person have to be away with a case of COVID before it's likely to endanger life within the premises.
Okay.
It may be that, hypothetical facts, if we're at the point where there are any cases in Sunderland, no one can persuade a court that they're likely to endanger life and property within the radius. But if there were a care home on the perimeter of the 1 mile radius and there was a number of contractions of COVID in that care home, that the court would conclude that was likely to endanger life in the premises.
What troubles me about this is there's a sort of mirror image going on here, or could be, that is it the incident that is within the 1 mile radius, or is it the endangering of the life within the 1 mile radius? And either possibility, you can proliferate examples in which you could say, well, I could imagine a problem a mile and a half away which endangers life within a mile, but I could also imagine an incident within a mile which doesn't endanger life within the mile but does endanger life generally or somewhere else, like a terrorist cell with a plan to blow up the Houses of Parliament, and you're talking about something in Bishop Auckland.
Yep.
So that either is at least conceivable as an example. So how do we arbitrate between choosing which one it is?
Well, I accept either is conceivable as an argument. The way you arbitrate between which one it is you start with the natural reading of the words in their context, and I've sought to persuade you that this is the natural reading, and I'm going to hopefully gain a little bit of support by the fact that Sir Richard Akins, who's much more authoritative than me, felt that they were the natural reading of the words in a very similar clause. So I'm just going to take you to look at that. Then you do have to look at what is the more commercial and reasonable result. So it's all of those factors. If we could turn perhaps to Sir Richard Akins' decision, this was a decision in the Salon Gold arbitration, and it came out 5 days after Mr. Justice Jacobs handed down his judgment. So Mr. Justice Jacobs didn't have the benefit of seeing what the arbitrator had considered in that case. And just to make clear, that was an award that was then made public by agreement between the parties, given the importance that it has to the COVID business interruption cases that are going through the courts. That is in volume 3 at tab 14. And so it's tab 14 and page 752. The wording is set out at paragraph 5. Losses insured under the section resulting from the actions or advice of a government or local authority due to an emergency likely to endanger life or property in the vicinity of the premises, which prevents or hinders the use of or access to the premises. Now, I quite accept that there are differences in the wording, most notably the word emergency rather than incident, and also the words in the vicinity of the premises rather than within a 1 mile radius. But the structure of the phrase is the same as the phrase we have in clause S30. The words in the vicinity of the premises follow after life or property, not after emergency. And one of the key issues in this case was whether the emergency had to occur in the vicinity of the premises or whether it was sufficient for coverage that the emergency, wherever it was, threatened life or property in the vicinity of the premises. And the critical passages of the award are at paragraphs 31 and 32. On page 764. And what Sir Richard Akins says in paragraph 31 is, coming to the definition of emergency itself, it is necessary to give all the words of the clause their natural meaning in their context. The natural way to read those words is in the order in which they are written. No word should be excluded in arriving at the meaning of particular words or a clause, unless that is the only way that the relevant phrase can be given some sense. Nor should the order of the words be altered, unless it has to be in order to give the relevant words or clause a sensible meaning. Here, the actions or advice of the government or local authority have to be due to an emergency. The draftsman then goes on to define what type of emergency is relevant. It is one that is likely to endanger life or property in the vicinity of the premises. That whole phrase makes perfect sense. There is no need to add comments to make sense of the phrase, nor is there any need to turn the phrase around so as to read an emergency in the vicinity of the premises likely to endanger life or property, in order that it should make sense. There is no warrant for extracting the words likely to endanger life or property in order to arrive at a satisfactory definition of emergency, so as to confine that emergency to the vicinity of the wording. He goes on in paragraph 32 to say, if I were just considering the wording in its context, I would have no hesitation in concluding that the only qualification placed on the words an emergency is that the emergency has to be likely to endanger life or property in the vicinity of the premises. I would conclude that it is not necessary that the emergency has to arise in the vicinity of the premises for there to be cover under this subsection. Then he goes on, and don't just go through it at length, but he goes on to consider whether, in light of a different decision that was reached by the divisional court in the FCA test case in relation to similar wording, but not identical wording, where they did hold that an emergency had to occur within the relevant geographical area, he was effectively bound to follow the decision of the divisional court. And what he concluded, and this is quite a lengthy passage which we've marked up from paragraph 34, in fact, I apologise, we haven't marked all the way up, but it goes all the way to paragraph 49, is that the point was not squarely argued and decided by the divisional court. He concluded that although there had been some argument on the point in reply by the FCA, the point hadn't been squarely decided. And if we just turn to paragraph 45, the court says the argument that Mr. Gruder has put for the claimants was not advanced by Mr. Edelman in opening. That's the argument that we're making here, that it doesn't have to be within the radius. I acknowledge that it was advanced briefly in Mr. Edelman's reply. The puzzle, therefore, is why this argument that Mr. Edelman made in reply, which both judges seem to think had some force, judging by their interventions, was not dealt with by the divisional court in its judgment on the RSA 2.1 and 2.2 wording. And then he says it's necessary to look at the structure of the judgment. And effectively he says, not quite clear why they didn't decide it, but they didn't address the points that Mr. Edelman had made in reply. They just assumed that the emergency had to be within the geographical area. And so Sir Richard Akins concludes that as the divisional court had not squarely decided the point, he was not obliged to follow their construction of a similar wording, and that he preferred his own construction. Now, we say that the reasoning of Sir Richard Akins as to how the clause reads naturally is to be preferred to that of Mr. Justice Jacobs in this case. As I pointed out at the outset, there are differences between the two clauses. There's emergency as opposed to incident, and there's in the vicinity of the premises rather than 1 mile radius. I accept that emergency has a different meaning to the word incident, and in particular, the requirement that an incident, inherent in an incident, that it's something which occurs in a particular place, isn't necessarily inherent in an emergency. I accept an emergency can be more, as it were, variegated and dispersed. But in our submission, those differences don't lead to a different conclusion as to the proper construction of this clause. And in particular, we say that the points made by Sir Richard Akins in paragraph 31 of the Saloon Gold Award about the natural way to read the words apply with equal force to our clause.
Does Sir Richard define the emergency? Is that anywhere? I think you've shown us talk a bit about it.
He accepts that the COVID pandemic as a whole is an emergency. Right. And I'm afraid I can't immediately give you a reference for that, but I will look that up over the short adjournment. Mr. Doherty helpfully has. Yes, sorry, paragraph 19, thank you. 19. Thank you. 19, it was common ground. Sorry, page 759, paragraph 19. It is common ground that by at least the 16th of March, the COVID-19 pandemic constituted a national public health emergency.
And was there any challenge to this award? Do we know?
I think the answer is no. It was handed down on 31st of January. I can find that out, but I don't believe that there was. And as I say, it was made public because it was felt that, like Lord Mance's award in the China Taiping, it may be of help to parties more generally. turning to commercial common sense, we say that the natural reading of the clause accords with commercial common sense because it is the fact that life or property close to the premises, within a 1 mile radius, is threatened, which will lead to the authorities preventing or restricting access to the premises. And as I said already, it's important to remember that the clause only responds where there is business interruption as a result of prevention or hindrance of access to the premises by a policing authority. So I don't get over the line if I prove an incident likely to endanger life in the vicinity or in the 1 mile radius. There has to be action by a policing authority which prevents or hinders access. So this isn't a sudden sort of widening of the clause and an opening up to cover in all sorts of circumstances in which I wouldn't otherwise have got it. The authorities, as my Lord Justice Birss has already suggested, might take action because and as a result of things which have happened close to the premises and which pose a threat to human life at the premises or close to the premises. But they might take it in response to incidents which are further afield, but which nonetheless are liable to endanger human life or property near to the premises. And that was a point which was made by Sir Richard Akins in Salon Gold at paragraph 33. And it's not hard to imagine such incidents. A gas leak, for example, which I think the insurers would say is the paradigm example of an incident that would be covered by this clause, might be slightly further afield but likely to endanger life within the premises. The effect of Allianz's construction is that where the premises have in fact been closed by a policing authority because of a threat to human life at or near the premises, the insured does not have cover if the relevant incident itself is outside the radius. And that could undoubtedly lead to some extremely arbitrary results. We gave the example in our skeleton of a gas leak 1.5 miles away as opposed to a gas leak 3/4 of a mile away. On Allianz's construction, in both scenarios the premises are closed because the authorities have considered that there's a danger to human life or property round our premises. But in one, the incident is outside the radius, so we don't get cover. On the other, the incident is within the radius, so we do get cover. Now again, I accept that cover could be limited in that way. And I accept that Lord Hamblins and Leggett made the point in the FCA test case that there can be benefits in having a clear rule which is relatively straightforward to apply, and that might outweigh the arbitrary effects of the rule. So obviously, cover could be limited in that way. It could be limited by requiring that the incident was within 1 mile of the premises. But when considering the rival constructions, you consider the commerciality of the rival constructions and the fact that Allianz's construction could lead to some extremely arbitrary results. So we say that Allianz's construction is neither the natural reading of the words as written, and we pray and aid there the points made powerfully by Sir Richard Akins, nor is it the commercially sensible reading of the words. The judge made this point. He said at paragraph 490 that if the incident could occur anywhere at all, it's difficult to see why the parties would have specified a 1 mile radius as a requirement. He said that if all that mattered is that there should be an incident somewhere which threatened human life or property, then the only concern of the parties would be whether access or use of the premises was prevented or hindered. Now, the same point can, of course, be made of the in the vicinity requirement in the Salon Gold clause, but that was not a point that troubled Sir Richard Akins. And what we say that the requirement that there is a threat to life or property within the radius does do is limit cover to circumstances where the action taken by the policing authority is sufficiently responsive to a threat to life in the relevant area. If I take an example to show you what I mean by that, suppose there were very serious riots in Liverpool. And it was decided by the government to impose a national curfew throughout the country, that all entertainment venues had to close at 10 p.m, not because they perceived any threat to life in London or anywhere sort of south of Merseyside, but because they decided that the simplest and most effective way to shut down the riots in Liverpool and to protect life elsewhere, i.e. in Liverpool, would be to impose a blanket curfew, a draconian response to an incident elsewhere. There would not be cover in those circumstances because the insurer will be able to say, yes, the policing authority restricted access to your premises. There wasn't any danger to life in the vicinity of your premises or within 1 mile of your premises, and there's no cover. And we say it does therefore have a purpose within the clause. So that's my answer to the judge's point at paragraph 490. That, subject to any questions that the court might have, was all I was intending to say on this point. My final ground of appeal, and just to sort of update you on timing, it is possible, you'll be glad to know that I may be finished by lunch, but I may just slip over slightly. The final ground of appeal is in relation to what was issue 28.4 at first instance, and that's the meaning of the words any policing authority. The judge dealt with this issue at paragraphs 494 to 509 of his judgment, and his conclusion is at paragraph 509, which is on page 225.
Just to understand the structure of the case, in order to reverse the dismissal of your claim, you need to win on both your first ground incident and this ground policing authority, but you don't need to win on your second ground. If you win on incident and policing authority, then the second point, which you've argued, only goes to what it is that will ultimately need to be proved.
Yes.
Is that right?
Yes.
Yeah.
So the judge's conclusion on this point is at paragraph 509, and he says, I answer this question as follows. Clause S30 refers to the police or other bodies whose function is to ensure that the law is obeyed and enforced. It does not extend to central government or the Secretary of State for Health and Social Care. And we say that the judge was wrong to conclude that the term any policing authority did not include central government, and wrong to conclude that it referred only to the police or other bodies whose function it is to ensure that the law is obeyed and enforced. Our submission is that the words used, any policing authority, are wide and flexible words. The words used are not the police, they are not the police or other similar body, they are not, as they are in some policies, the police or other competent local authority. They are simply any policing authority. And we say the word any is obviously inclusive. It's not limited to particular policing authorities, it includes any policing authority. Now, policing authority is not a term with a fixed, well-known meaning. There is, in fact, no body which is called a policing authority. As you may have seen from the judgment, there did used to be such things as police authorities, and police authorities were responsible for each of the territorial police forces in England and Wales. But those police authorities were, as it were, responsible for the supervision of police forces. They would never have been an entity that was responsible for preventing or hindering access. Those police authorities were abolished in 2011, And I think no party suggests that policing authority is to be construed by reference to police authorities. They never had the function of closing premises. So the words policing authority certainly do not have an established meaning in the same way that local authority might do. And what we say that these words mean in the context of this clause is simply anyone who has the authority or the power to police in the sense of preventing or restricting access to the insured's premises. And that is because the only policing that this clause is concerned with is policing in the sense of regulating access to the insured's premises. So very simply, any policing authority means any body which has authority to prevent or restrict access, i.e. to police access. And the bodies which have such authority include the police, some emergency services, some local authorities, but also central government. Now, I don't intend to trawl through the numerous statutes which give powers to all of those bodies. There's a very helpful exposition in the award of Lord Mance in the China Taiping arbitration, another one that was made public to sort of assist other insureds and insurers, of the various bodies which have power to prevent or restrict access to premises. And put simply, police, local authorities, central government, traffic authorities, highways authorities. And I'll come on to look in a bit more detail. But there's a lot of different bodies that have power to prevent access to premises in response to emergencies or dangers.
On your construction, does the word policing add anything? Would the clause mean exactly the same if it simply said prevented or hindered by any authority?
Well, my Lord, I take the point. I think the question would be if we were standing in front of you saying, what does any authority mean? There'd be more scope for argument about not scope for argument, there'd be sort of even greater question as to what's meant by any authority. If you say a policing authority in the context of a clause which is about preventing or hindering access, that focuses the inquiry. What policing are you talking about? You're talking about the policing of access. So I do say it adds something. It has to be an authority which is capable of policing access to premises. What it doesn't do, of course, is say local authority, which some of these clauses do. Mr. Doherty rightly says that you don't have to decide in this case precisely where the penumbra of the term lies, because all you need to decide is whether central government can fall within the definition of policing authority. But I suggest it's helpful to explore the penumbra a little bit to test Mr. Doherty's assertion that on no sensible view does a policing authority extend to any organs of central government. I think it's common ground that any policing authority would include police officers. Police officers have common law powers to cordon off areas. They have powers pursuant to various statutes to restrict or prevent access to premises or areas. We say that any policing authority would also encompass the fire and rescue authorities. Employees of fire and rescue authorities have the authority to do anything they consider appropriate for the purpose of carrying out their functions. And they have specific powers to prevent entrance to and access to premises. So a firefighter can shut down a premises in the event of a fire. The role of the firefighters and fire brigade isn't in any general sense policing, in the sense of ensuring that the law is enforced and obeyed, but they do have ability to police in the sense of prevent or restrict access to premises, specifically and particularly where life or property is in danger. And if one considers what insurers often say is the paradigm example of a clause which would be covered by this clause, it's a gas leak. In a gas leak, the first responders, the people who are likely to close the premises, are firefighters. We say any policing authority would include firefighters because they have the ability to restrict access to premises. We also say that any policing authority would encompass traffic authorities, because traffic authorities also have powers to prohibit, restrict access to roads, including because of the likelihood of danger to the public in or near the road.
You keep referring to powers. So the powers of the traffic authorities obtained from where?
Well, the Road Traffic Regulation Act.
Right.
The vast majority of the powers are statutory powers.
Yes, and the powers of the fire brigade obtained from where?
Statutory powers.
Yeah. And the powers of the police obtained from where?
Some are statutory, some are common law.
Common law,
powers.
yeah. So are there any examples you refer to where powers of actual restriction are granted to other than those types of organisations? Because they're certainly not granted to MPs, are they, or to
No, my lady.
secretaries of state?
Well, they are granted to secretaries of state, and that's exactly the point that I'm coming to
From
make.
where?
Well, in two principal statutes, although there are some other statutes. One is the Public Health Control of Disease Act 1984. That is the statute under which the regulations were passed by Matt Hancock, and they specifically gave powers to the Secretary of State to make the regulations that he made that close theatres.
Right.
The other main statute is the Civil Contingencies Act 2004, which again gives central government specific powers to close premises or areas in response to certain dangers and emergencies.
But could you, and this is not putting a point, it's asking a question. Could the powers that Secretary of State for Health had naturally be termed policing? Because policing usually suggests an enforcement of legislation or regulation. So if somebody defied the regulations, it would be policed. The regulations would be policed by another body.
Well, my lady, except that is one way in which the term policed is used. But if
Yeah.
I just give you this example,
Yes, of course.
a police officer comes to the scene of an event or an incident where, say, there are rioters running up and down the Strand, or a firefighter comes and a fire is raging on the Strand, and he decides that the Savoy Theatre must be closed in order to protect life. He makes an order there and then that that the Savoy Theatre must be closed, and he prohibits access. He might have constables who help him enforce that, but it's the police officer who makes the order closing the premises. He does so to protect life, and he has the power to do that. And that is exactly, I say, the same function that the Secretary of State was performing when he made regulations that closed theatres in order to protect life. Neither one of them is enforcing existing regulations which exist. What they are doing is making an order preventing access to the premises.
Is that right? Because the police officer going to the scene of a theatre that was quite obviously having a lockdown party or something like that.
Sorry, my lady. There, I accept that if the police came and, as it were, there was a lockdown party happening at the Savoy Theatre, he would be enforcing a rule that had been made by Matt Hancock.
He would be policing it. He would be policing the rule, wouldn't he?
One way to describe it is policing the rule. Another way to do it is saying enforcing the rule. Yes, I accept that.
Right.
But I'm saying that he ordinarily, the police officer or she, when they come to a scene of an incident or an event where something has happened, when they make an order restricting access to the premises, or a traffic authority or anyone else makes an order closing off a thing, they're not enforcing any existing rules or regulations, they are making an order, they are taking action to prevent or restrict access. They do so pursuant to their statutory powers, or in the case of a police constable, their common law powers. And as I say, that's exactly what we say that the Secretary of State was doing.
Can I make sure I've understood? I think, if I put it in my terms, the point you're making is if there was a gas leak and it happened to be a policeman who was standing there and the policeman closed the premises, they're not enforcing the law when they do that.
Right.
Because there's no maybe a law broken because there's a gas leak, but that's not the point. The point is it's dangerous. And that's the point you're making.
Absolutely.
That's the distinction.
Yeah. Absolutely. When you are preventing and restricting access to premises in response to an incident likely to endanger life, very unlikely actually it's the enforcement of an existing rule. It's much more likely that it's just a reaction to the situation and making an order that is responsive to that situation.
I wonder if over the short adjournment you could find me the line of continuation from the regulation that permits a police officer who determines that a premises is a danger to health, then closes down the premises with cordons and all the rest of it.
Yeah.
I'd like to see the continuum, but do it over the short adjournment.
My lady, I will. The reason why I've sort of hesitated is there are so many statutes that one could get into. It might be helpful to look at, in due course, at what Lord Mance said in China Taiping, where effectively what he had was the insurers saying, look, local authorities have all these powers, local bodies have all these powers, local bodies like the police or highways authorities or local authorities, and the insureds were saying, yes, but so did central government have the same powers. Because the argument that was being made in that case was that competent local authority included the government. And what was being said by insureds was, the government has all these powers to prevent access to premises in the same way that local authorities do. And therefore, when it referred to competent local authority, it meant the government acting locally.
Well, that clause included local authority, however, didn't it?
It did,
Yes.
and Lord Mance
And
held
not policing authority.
it did.
So I'd just like to see, because at the moment that's where I'm struggling to see the similarity between a legislator and the enforcement of legislation by a policing authority who are required statutorily to abide by the law of the land and to enforce it.
Well, my lady, I understand the point, and I think it will be helpful, and I'll obviously provide copies to my friend
Yes,
of
thank
relevant
you.
statutes, but just to make the point, and I can then show you in more detail, some of the same statutes which afford powers to the police or to local bodies also afford powers to central government. So it's the same statute which is giving powers, if I can put it like that.
It may do, but you've still got to get it within a policing authority. It may be that the local authority has its own officers. For example, a health inspector can close down a restaurant because it's found vermin in the kitchen.
Yes.
He or she is policing the regulation. It's not the local authority doing it itself. It's done vicariously through the officer. So that's just what I'm interested in, amongst other things, obviously.
I'll try and help you with the short adjournment. But the fundamental point that I am making is that, which is exactly my Lord Justice Birss's point, that when a police officer or a firefighter comes to a dangerous scene, he's not enforcing rules in the same way that your local inspector was just enforcing sanitation rules. What he's doing is acting within his powers, which are to do anything necessary to protect life or property in some instances, to prevent access to premises. So it's not a question of enforcing any existing rules or regulations. So the act of policing there, the relevant act of policing, the prevention of access to premises, is not the enforcement of existing laws or regulations. It's the act of policing that is being referred to is preventing access to premises in order to protect human life. And we say that is what a policing authority, any policing authority, means in the context of this clause.
Well, I look forward to seeing your example. Thank you.
And really, this is Mr. Doherty's main point. His point is that what the government does is regulate or legislate, and that is a fundamentally different role, he says, from policing. And my point, which I've already made, and I will try and make good by reference some statutes, is that when someone shuts down a building because they're worried about a danger to life, they're not enforcing rules, they are themselves regulating or legislating in the same way that Mac Hancock was doing when he made those rules. So
I'm sorry, I briefly got to question that now, but how could a police officer do so without the regulation?
Because the police officer has a common law power to call, and again, this is set out in Lord Mance's.
Yes,
and
okay.
I'll take you to it after.
So a police officer does. So, and we've already decided that there's no one who's going to say that a police officer is not part of a policing authority. But we know that citizens can make citizens' arrests if there is an indictable offence about to occur, which carries more than 5 years imprisonment. So,
but they can't close premises.
No, that's the point. So they have no right, because they have no statutory power or common law power or regulatory power to do so. So I'm not sure where the local authorities therefore come into it, or state authority comes into it as a policing authority on that same comparison.
Yes, I think, could I just show you a little bit of Lord Mance's award, rather? If we go to Volume 1, Tab 1 of the, Tab 5 of the Authorities Bundle. At page 134. Starting at page 78. And just to remind the court...
sorry, did you say tab 1?
Sorry, tab 5.
Tab
sorry,
5.
I do apologise. Tab 5 at page 134.
Thank you. Yeah.
And just remind the court, what Lord Mance was considering here was a clause which covered the closing down or sealing off of the premises in accordance with instructions issued by the police or other competent local authority. So the question was, does the government constitute other competent local authority? And Lord Mance held it didn't. And what Lord Mance was doing at paragraph 78 following was looking at the potential forms of official intervention in respect of perils such as those identified in extensions 1, 2 and 8. And put broadly, extension 1 was an emergency threatening life or property in the vicinity of the premises. And clause 2 was things like disease, infestation, defective sanitation. And exclusion 8 was a terrorism exclusion. So Lord Mance was looking at the various powers that various bodies have in those circumstances. And then what Lord Mance said is there is legislation enabling central government intervention and legislation enabling local intervention. It's wrong to concentrate on either. And the fact that they are both, in some contexts, in the same statute does not mean that both were intended to be covered by this policy wording. And then at paragraphs 79 and 80, he discusses the two main statutes which give central government authority to intervene in sort of emergencies threatening life or property, which are the Public Health Control of Disease Act and then the Civil Contingencies Act. And then there's a long explanation of the various powers. And the powers that were, in fact, used by Matt Hancock in passing the regulations that he did are these powers under the Public Health Act, which as you see at the top of page 135, section 45 confers powers on the appropriate minister to make regulations for the purpose of preventing, protecting against, controlling or providing a public health response to the incidence or spread of infection or contamination in England or Wales. And this was all the agreed facts in the FCA test case. The regulations were made under this and they required the immediate closure of all theatres, nightclubs, etc. So what I say is there was a statutory power which gave a minister a power to make a regulation. He made a regulation and he did so in a way that enabled that to be enforced by the police. And I say that in making that regulation, in exercising that power to restrict access, he was acting as a policing authority. Over the page, and these are, just to make clear, the insured submissions rather than Lord Mance's finding, but there was no issue taken with any of this by the insurers in that case. Paragraph 77.1 on page 136, it says that the Act plainly contemplates the powers conferred on the Secretary of State under section 45 being used to take action locally, regionally or nationally as circumstances require. And as my lady will know, that is what the Secretary of State did, because initially he made national regulations, but subsequently in September and October, a whole series of very localised regulations were made. So very specific areas were closed down in lockdowns, and the regulations only related to very specific areas. And we can, if it helps, we can give my lady a list of those, but they were local regulations that were made. They closed premises in particular towns or particular areas. I think, although I'm probably corrected, that Birmingham was the first. Sorry? Leicester, I apologise, it was the Leicester.
Yes, I recall the local lockdowns, but I'm not sure that goes to the point I'm asking you, really, because it's still required to be policed. If the policing authorities are defined by their ability to police,
yes, my lady, my point on that is, what does police mean in the context of this clause, where all it's interested in is the restriction of access to premises?
Well, it also goes into the definition of incident, I'm sure Mr. Doherty would say, on the basis that COVID can't be policed. It can be regulated in terms of restriction, but it can't be policed. But that's another, that maybe he's not going to say that, I don't know.
I mean, Mr. Doherty will tell you
yes, of
what
course,
his case is.
but what I'm trying to say is it doesn't necessarily mean that because you can say that there's been local lockdowns or it's been regulated, that policed actually can be divorced from the rest of the clause.
No, and I don't say the police can be divorced from the rest of the clause. I accept that, of course, it must be read in the context of the clause, but you've heard my submissions on what an incident means and where the incident has to be. What I say is, when you construe the words any policing authority in the context of this clause, it has to be understood absolutely in the context of this clause. What this clause is interested in is whether someone has shut down a premises.
Right.
That is the policing that is being referred to. And the point that I'm trying to make is there are lots of different authorities who don't police in the traditional sense of being police constables, who have the authority to shut down premises. One of those is the Secretary of State by making regulations such as the ones he in fact made. Another is the Highways Authority. Another is the Fire Brigade. And
those people seem to be listed in paragraph 85, where
those
the sets out
exactly
police officers and fire and rescue and trafficking powers.
My Lord, yes. Paragraph 85 was the sort of overview by the insurers, and this was insurers trying to make the point that lots of local authorities have all these powers to shut down premises, and these were the various authorities which they said had local competency, and that's therefore what was covered by competent local authority. But My lady, my point, and then I'll stop for the short adjournment, and I won't be too much longer after the short adjournment, is my point is this: if you're looking at a clause which closes down access, that's what it's interested in. Has access to your premises being prevented? You look at who has powers to prevent access, and they are, as my Lord Justice Mills just pointed out, that the people set out, first of all, in the paragraphs I was looking at, the organs of central government, and all these local bodies. Now, none of those local bodies, in the sense of the fire and rescue authorities, the highways authorities, they're not policing in the sense of enforcing existing regulations when they exercise their powers to shut down premises. What they are doing is making an order preventing access in order to protect life or property. Now, of course, my lady, I accept that in some instances, when a body is closing down premises, it will be because it is enforcing existing rules. And my ladyship's example of a sanitation officer coming round and seeing that existing rules were not being complied with, that would be enforcing an existing rule. But most instances of shutting down premises in response to dangerous incidents or events is not enforcing any rule. It is policing in the sense of preventing access to protect life and property. And that is exactly what we say Hancock was doing when he made the regulations. My lady, it's probably a convenient...
I think it probably is. Thank you very much. But you think you're going to be another quarter of an hour, 20 minutes or so?
Yes, not more than that.
All right. All right. Well, Mr. Doherty can gird his loins ready.